Before I read this appeal, I do want to show you a judge's oath, what a judge must swear to, that they will administer justice without prejudice to persons and do equal right to the poor and to the rich, and that they would faithfully and impartially discharge and perform all duties incumbent upon them. So help me God. I too took the oath for the military that I would protect and obey the orders of the president. I did that oath 4 times serving in the U.S. Navy. So here's a few points I want to make about this appeal. The appeal was written after Judge Don Hall of Arcadia, Florida, heard the facts spoken by Mr. Henry in a court hearing in January 2023. Judge Don Hall denied Mr. Doby his freedom because he said Mr. Henry's testimony was not credible. And here is the results. I will not be citing the cases in this brief. There's some things I will skip over. If you're watching this on YouTube, you'll be able to see on the screen. If you are listening to this via podcast or any other means, you won't be able to see any of the numbers. If I misspell or mispronounce a word, not misspell, but if I mispronounce a word, just ignore. I'm doing the best that I can. I'm not trained as a law person. I haven't been to law school or anything like that, but I'm just doing this out of the kindness of my heart. So here we go.
The trial court erred by denying Mr. Doby's successive motion to set aside and vacate judgment and sentence pursuant to Rule 3850, alleging newly discovered evidence. In its answer brief, the state asserts that the trial court's credibility determination of Mr. Henry's recantation is supported by evidence and that, even if credible, Mr. Henry's new testimony would not create reasonable doubt on retrial. The appellant respectfully disagrees. Initially, the state finds the trial court's credibility assessment by minimizing the court's erroneous reliance on Mr. Henry being free from prosecution for perjury. In the state's view, because the trial court pointed to other reasons for finding Mr. Henry's recantation unreliable, the court's finding regarding the prospect of a perjury charge is merely harmless. But this ignores the importance of a thorough credibility determination in a newly discovered evidence case that relies on an admission of perjury. And here's the case that they referenced. In assessing whether Mr. Henry's recantation was credible, the trial court, under the mistaken belief that Mr. Henry was recanting risk-free, thus its entire assessment of Mr. Henry's recantation was flawed. Here's a reference to A.C. Shepard versus State, noting that the lower court failed to observe the witness recantation could have resulted in persecution for perjury under this section. That was based on witness previous trial testimony. That's based on that case. And it is impossible to have confidence in the trial court's credibility assessment when the court relied heavily on a plainly incorrect perjury finding. Contrary to the state's assertion, the trial court's reliance on the incorrect perjury finding was not so minimal as to render it harmless. Indeed, the incorrect perjury findings seeped into other credibility factors. For instance, the trial court's consideration of the length of time it took Mr. Henry to come forward, a critical fact relied upon below and on an appeal, was influenced by the trial court's erroneous perjury finding. After highlighting the time lapse, quote unquote, as an important factor in addressing credibility, the court then stated, quote unquote, a time lapse is particularly relevant where the recantation is made after the statute of limitation of perjury has expired, and they reference a page number in a case. In other words, the trial court's consideration of Mr. Henry's delayed recantation was influenced by the incorrect perjury findings. In an effort to minimize the trial court's incorrect perjury finding, the state contends because the court did not explain how it arrived at that conclusion, it could have been referring to the prosecutor's argument regarding the impossibility of proving a perjury case against Mr. Henry. But a review of the express language used in the trial courts leaves no room for guessing. After noticing that the statute of limitation for perjury had expired and that Mr. Henry's time in prison was coming to an end, the court stated, quote unquote, with his release being imminent and the impossibility of his being persecuted either for perjury in his original statement or as the actual shooter due to the constitutionality prohibition on double jeopardy, there's virtually no risk for Mr. Henry. Duh. Thus, it is clear that the trial court was under the mistaken impression that Mr. Henry was recanting without risk of being prosecuted for perjury. The trial court's erroneous finding is buttressed, I don't know that word, by the fact that Mr. Henry has formally been charged with perjury. This underscores that the trial court's entire assessment of Mr. Henry's recantation is faulty, and he is now subject to punishment for a second-degree felon, according to this Florida statute. Had the trial court properly analyzed Mr. Henry's recanted testimony, taking into consideration his risk for prosecution for perjury, the trial court may have concluded that Mr. Henry's recantation was true, and Mr. Henry's new testimony, I don't know how to pronounce that word either, Mr. Doby, would probably create reasonable doubt on retrial. There's some other cases that they reference. On retrial, a jury would hear evidence consistent with Mr. Henry's recantation, including that the direction in which Mr. Henry fled and hid from the police after the shooting is consistent with where the gun was eventually located. There will also be testimony from Ruiz, an eyewitness to the crime, that the shooter held the gun in his right hand. Mr. Henry is right-handed and Mr. Doby is left-handed. I repeat, Mr. Henry is right-handed, Mr. Doby is left-handed. The jury on retrial would also hear evidence of the tainted investigation conducted by the Arcadia Police Department, including that Mr. Henry's cousin, Detective Charles Lee, had an unrecorded conversation with Mr. Henry, encouraging him to help himself and label Mr. Doby as the shooter to avoid the death penalty. That Mr. Henry was permitted to speak with his mother despite being a suspect in a murder. After his mother spoke to Detective Lee, let me back up. Mr. Henry was encouraged to help himself and label Mr. Doby as a shooter to avoid the death penalty, and that Mr. Henry was permitted to speak with his mother despite being a suspect in a murder after his mother spoke to Detective Lee, and that Mr. Henry was permitted to wash his hands before the gun residue testing was conducted. In sum, The trial court's finding that Mr. Henry's recantation was not credible was tainted by an incorrect legal conclusion, which was the judge's opinion and his power. Sorry. Mr. Henry was, in fact, subject to a maximum penalty of 15 years in prison for perjury. Mr. Henry came forward with his new testimony despite such a significant risk to himself, but the trial court's failure to consider that risk rendered its assessment of Mr. Henry's credibility flawed. Had the court properly considered the significant risk to Mr. Henry, may have concluded that his his recanted testimony was true. And when evaluating Mr. Henry's recantation against the evidence in Mr. Doby's 1999 trial, it is apparent that a different outcome is probable. And here's the conclusion. Accordingly, this court should reverse the trial's court order and remand with instructions to vacate Mr. Doby's conviction and sentence. However, if this court is unable to reach that remedy, at a minimum, this court should remand to the trial court with instructions to reassess Mr. Henry's credibility in light of his significant risk of facing persecution for perjury.
Why did he not feel Mr. Henry's testimony was not credible? Was it because Mr. Henry challenged the institutional loyalty of Judge Don Hall to the Arcadia Police Department, even though the judge is supposed to be impartial? And Mr. Henry, he exposed a flawed system and revealed a real truth that probably was uncomfortable about a former detective, Mr. Charles Lee, who later became a sheriff of Arcadia. And so maybe, just maybe, all of his cases would be overturned. I don't know. So if we believe, this is a question for a judge, if he believed Mr. Charles Lee, if he came to court and he came forward and testified that what Mr. Henry said was truth under oath, and maybe took a lie detector because you don't seem to believe people, would the judge then do right by Mr. Doby? It's just a question. So just who will Judge Hall believe if he doesn't believe the actual shooter out of his own mouth? I'm just asking for a friend and family.